ASME versus Hydrolevel Corporation. This is a tort law case with the driving factor being a conflict of interest. So here's the background. In 1941, an engineering firm owned by McDonnell and Miller planned on taking down their competitor, Hydrolevel, by creating an ASME boiler and pressure vessel code. How would they do this, you ask? Well, they were part of the ASME Boiler and Pressure Vessel Code Committee. Now you see how this could be a problem really fast. McDonnell and Miller created a code that when reviewed against Hydrolevel, they will immediately fail and be deemed unsafe. So a salesman working for the McDonnell and Miller firm requested an interpretation of this code, and unknowingly of the ASME's leadership, the volunteer chairman of the committee wrote a response to him, in which this response was used as proof of Hydrolevel's non-compliance. This plan was successful, and it resulted in Hydrolevel filing for bankruptcy. Now, this violates a plethora of ethical dilemmas that we will dive into. First, under professional misconduct, section 72.2a, negligence. The ASME were negligent in taking action against the two subcommittee members that were acting without permission. The consequence of this would be that the subcommittee members would get fired, fined, or even suspended of their licenses. Next, section 72.2.I.4, which is contracting in the practitioner's own right to perform professional engineering services for other than the practitioner's employer. So in our case, McDonnell and Miller made the code with a self-interest to take down the competition. So a consequence of this is that both of them being fired, fined, taken to court, and losing their license. Now, under the Code of Ethics, there was also a section that was violated, section 77.3, which the key part is that a practitioner shall avoid or disclose a conflict of interest that might influence the practitioner's actions or judgments. So clearly, McDonnell and Miller did not disclose their conflict of interest and knowingly created a code for their self-benefit. Now, since this is section 77, it is taken more lightly than 72. So a consequence of this would be that both of them would only lose their jobs. Now let's analyze 3 paths forward to prevent this from happening. So the temporary chairman should have consulted with the ASME leadership instead of doing this with them not knowing, and they might have been more prepared and knowledgeable than him being just a volunteer. Path 2 is to advise McDonnell and Miller to not go forward with their plan after thoroughly inspecting the code, as it is based solely on self-interest. More than one person should have checked the code and thus resulted in them knowing their plan and preventing it. Path 3 is to advise other employees in the committee to show that the doings of McDonnell and Miller are unjust, and if no one agrees, then contact and inform PEO, who will handle the situation by interviewing the members. So our decision is a mix of these, which is that McDonnell and Miller should have disclosed their conflict of interest, and other committee members should have been involved in creating this code and analyzing the boiler. Also, ASME should have been more involved in knowing what their subcommittee members were doing. If no one in the ASME agreed to take action, then the PEO should have been contacted and they would deal with the situation at hand. And if someone is too scared to report the case, then the complaint could be made to the complaint committee, who would also deal with the situation. Now, looking at the law side of this case, this is a tort law case involving a conflict of interest. So Hydrolevel has been wronged, and the law is trying to right the wrong where the person is owed a duty of care. So we go through the tests, which the first test is that a duty of care is owned by the defendant. Test 2 is that a duty of care was breached, and test 3 was the plaintiff suffered loss or damage due to that breach. So the precedents are Donahue versus Stevenson, which is the snail in the ginger beer, Hedley Byron versus Heller, 1964, Wolverine Tube versus Noranda and Arthur Little, 1994, and Winnipeg Condos versus Bird Construction, 1995. So the parties that were involved is that the plaintiff, which is Hydrolevel, and the defendant, which is ASME and McDonnell and Miller. Since there are multiple defendants, this is called concurrent legal fees in tort law. So let's go through the tests. So the ASME failed in the duty of care because ASME did not conduct its due diligence, and the Hydrolevel suffered a major loss in reputation and went bankrupt. For McDonnell and Miller, they failed the duty of care by creating codes for their self-interest to harm other companies, and Hydrolevel went bankrupt and lost their reputation. So the damages and liability, the two types would be punitive and consequential. So a defendant would get punished since they were negligent, and this will prevent the future companies from suffering the same fate. And also there was a loss of income, which Hydrolevel went bankrupt, and they also lost the potential profits they could have had. So the decision was that McDonald and Miller had their licenses revoked, and the Supreme Court found in favor of Hydrolevel for $6 million in damages and liabilities that the ASME had to pay.